All right, so today we're diving into something that can be a real headache.
Oh, yeah.
Bankruptcy when you're financially tied to someone else.
It's a common situation, actually, more than people realize.
Right, like when you co-sign a loan or share credit or even have property in another person's name.
Exactly. All those things can make bankruptcy feel like a huge risk.
Like one wrong move and everything collapses.
It can feel that way. But the good news is, even these messy situations can be handled the right way,
With the right knowledge.
with the right knowledge and help.
So let's start with joint debts.
Okay.
Say you co-signed a loan with someone and now you're the one filing for bankruptcy. What happens to that debt you both share?
Well, it doesn't just disappear for everyone just because you file.
Oh.
Yeah, bankruptcy mainly affects your legal obligation to the creditor.
So
So your friend, the co-signer, they're still on the hook for the whole amount.
that doesn't sound very fair for them.
It can be tough, and it shows why it's so important to understand what bankruptcy means for everyone involved.
Yeah, for sure.
And how it all plays out can also depend on what type of bankruptcy we're talking about. Chapter 7 or Chapter 13.
Okay. Most of our listeners probably know the difference between Chapter 7 and Chapter 13, but can you quickly explain them again?
Sure. In simple terms, Chapter 7 is about liquidating assets to pay off debts. It's often called straight bankruptcy.
And Chapter 13?
Chapter 13 is more about creating a structured repayment plan. You work out a way to pay off your debts over time, usually 3 to 5 years.
So if someone files for Chapter 7 and they had a co-signed loan, would their part of the debt be completely gone even if their friend is still responsible?
Yeah. In a Chapter 7 bankruptcy, your personal responsibility to the creditor could be eliminated.
Could be.
Could be. It depends on the specifics of your case and what assets you have. But even if it is eliminated, it doesn't change anything for the cosigner. They're still liable for the full amount.
That does raise some ethical questions. What if someone's not too concerned about the cosigner? Can they just use bankruptcy to get out of the debt and let the other person deal with the consequences?
Legally speaking, yes, you could potentially do that.
Really?
But remember, everything we do has consequences. So while you might be legally in the clear walking away, that could seriously damage your relationship with the cosigner.
Right. It's not just about the legal stuff, but the ethical side of things, too.
Exactly.
Okay, so that's Chapter 7. What about Chapter 13? How does filing under that affect a cosigner?
Chapter 13 is a bit different because it involves setting up a repayment plan.
Right.
And if it's structured properly, that plan can actually protect the cosigner. As long as you stick to the plan, creditors usually can't go after your friend for the debt.
So Chapter 13 could be a way to protect both people involved.
Exactly. It can offer a more balanced solution.
That's interesting. So there's a pretty big difference between Chapter 7 and Chapter 13 when it comes to co-signed debts.
There is. And that's why having a good attorney is so crucial. They can help you figure out which option is best for your specific situation.
Okay, that makes sense. Now let's talk about a slightly different situation. Let's say you promised to pay someone else's debt, even though you didn't actually co-sign the loan.
Ah, those informal agreements.
Yeah. Like when a friend needs help and you say, don't worry, I gotcha. But then your own finances take a hit.
Happens all the time, especially between family and close friends.
Exactly. It's not legally binding, but it feels like you have a moral obligation.
Right. And that's where things can get complicated in a bankruptcy.
So legally speaking, who are you actually indebted to in this scenario?
Legally, you only owe the person who took out the loan, not the creditor themselves.
Because the creditor doesn't even know you're involved.
Exactly. They have no clue. So from their perspective, it's purely between you and your friend.
So it's more like a personal agreement than a formal debt.
That's right.
How does that play out in Chapter 7 versus Chapter 13 bankruptcy?
Okay, so in Chapter 7, you could list that promise to your friend as part of your overall debts.
As a personal debt.
Right. Since it's not an official loan agreement, it's treated as a personal debt. And in Chapter 7, that debt could be discharged along with your other obligations.
So you wouldn't be legally required to pay your friend back anymore.
That's correct.
But what about the original borrower? Are they off the hook too?
That's where it gets a little tricky. Unfortunately, no, your friend still has the official debt with the creditor.
Right.
And even if you're no longer legally obligated to pay them back if they default, the creditor can still come after them.
Wow. So even if you're trying to help by taking on their debt, things could still backfire on your friend.
Yeah, it's a bit of a domino effect. Your bankruptcy could end up hurting them in the end.
That's rough. It seems like these informal agreements come with a lot of hidden dangers.
They do, and that's why it's so important to understand how bankruptcy affects these situations, both for you and the other person.
So Chapter 7 could actually make things worse for the original borrower. What about Chapter 13? Does that offer a different approach for these informal debts?
It might. Chapter 13, with its focus on repayment plans, could give you another option.
Instead of wiping out the debt completely.
Right. Instead of just erasing it, you could potentially include your obligation to your friend in your repayment plan.
Oh, so you'd still be honoring your commitment to them, but in a more structured way.
Exactly. You'd be working towards overall financial stability while also taking care of that personal debt.
That seems like a much better solution for everyone.
It could be, but again, it really depends on the specific circumstances and what makes sense for your situation.
Right. It sounds like these informal agreements can be pretty tricky to navigate.
They can, and having professional advice is essential to make sure you're making the right choices.
Okay, so we've covered joint debts and those informal, I'll pay your debt promises. Now let's move on to another common situation, property or loans that are in someone else's name.
Yes. This one comes up a lot.
Like my car is in my brother's name because my credit is bad.
Exactly. Why do people do this? Well, there are a few reasons. It could be bad credit, trying to protect assets, or sometimes even trying to hide ownership.
I can see how that could become a problem,
Yeah.
especially when bankruptcy is involved.
It definitely can. The thing is, the person whose name is on the legal papers, whether it's a loan title or registration, they're ultimately the one responsible.
Even if someone else has been making the payments all along.
Even then, legally, they're the ones on the hook.
So if my car is in my brother's name and I file for bankruptcy, he's still the one who could get in trouble.
That's right. And it gets even more complicated when you add in things like security interests.
Security interests.
Yeah, let's say you finance that car. The creditor has the right to repossess it if the payments aren't made, regardless of who's been driving or paying for it.
So putting an asset in someone else's name doesn't make it invisible.
Nope, not at all.
What about the bankruptcy court? Do they just take your word for it if you say that a certain asset isn't yours?
Bankruptcy courts are pretty thorough. They want you to disclose everything about your finances, including any assets held in someone else's name.
So trying to hide things is a bad idea.
Very bad idea. It's a big red flag for the court and could lead to serious legal trouble.
Like what kind of trouble?
Well, they could deny your bankruptcy discharge, meaning your debts wouldn't be erased.
Oh, wow.
And in some cases, it could even lead to criminal charges.
So honesty is definitely the best policy here.
Absolutely. Trying to outsmart the system is never a good idea.
So if someone's thinking about filing for bankruptcy and they have assets or debts connected to other people, what should they do?
Be completely honest with their attorney. Tell them everything about joint debts, informal agreements, properties in someone else's name, everything.
Because trying to hide stuff will only make things worse.
Exactly. Bankruptcy is supposed to be a fresh start, but you have to build that fresh start on honesty.
Transparency is key.
Exactly.
But all of this can feel overwhelming.
It can be. That's why it's so important to have an experienced attorney in your corner.
Someone who can help you understand your options.
Right. They can guide you through the process, make sure you're following the rules, and help you come up with a plan that protects your interests.
Speaking of experience, I know Geraci Law has dealt with a lot of these tangled financial situations.
Oh, yeah. Geraci Law, founded by attorney Peter Francis Geraci, they've been helping people with bankruptcy for over 40 years.
So they've pretty much seen it all.
They've seen a lot, that's for sure.
Yeah.
From hidden assets to those well-intentioned but legally questionable arrangements you were talking about earlier.
So what's their approach when dealing with these complicated cases?
They focus on honesty, transparency, and finding solutions that work for everyone involved.
Solutions that are fair and ethical?
Exactly. They understand that bankruptcy can be stressful, especially when other people are involved. So they work closely with their clients to figure out the best way to move forward legally and ethically.
It sounds like they really care about their clients and not just treating them like another case file.
They do. They have a very human approach to a process that can often feel cold and impersonal.
So before we move on to some real-life examples, what's the biggest takeaway for our listeners when it comes to bankruptcy and dealing with other people's finances?
The biggest takeaway is this. If you're considering bankruptcy and your money is mixed up with someone else's, don't try to do it alone.
Get help.
Get professional guidance from a qualified attorney. They can explain your obligations, protect your rights, and help you find the best path forward for everyone involved.
And being upfront and honest is crucial throughout the whole process.
Couldn't have said it better myself.
Great advice. Now let's dive into some real-world examples to see how these financial entanglements can play out in bankruptcy. Stay tuned. We'll be right back after a quick break.
Welcome back.
Let's get into some real-life examples now and see how these financial entanglements can actually play out in bankruptcy.
Sounds good. At Geraci Law, we've seen a lot of situations where clients have tried to navigate bankruptcy while also dealing with assets or debts that are connected to other people. And while we can't share specific cases because of confidentiality, we can definitely talk about some common scenarios to show you how complicated things can get.
That makes sense.
Uh,
Let's start with property.
uh.
What are some examples you've seen where people try to protect an asset by putting it in someone else's name?
Well, one thing we see sometimes is someone who's facing financial trouble might transfer ownership of their house to a family member.
Oh, to try and shield it from creditors.
Exactly. They might keep living in the house and even making the mortgage payments, but legally the property isn't theirs anymore.
So they're basically trying to create this illusion that they don't own the asset anymore.
Right. But does it actually work in bankruptcy court? Not usually.
Oh, really?
Bankruptcy courts are pretty good at spotting these kinds of transfers, especially if they happen right before someone files for bankruptcy.
I guess they've seen it all before.
They really have. They'll look at when the transfer happened, the relationship between the people involved, and any signs that the person was trying to hide assets.
So it's not as simple as just signing over a deed.
Nope, not at all. What happens if the court finds out that a transfer was made to hide assets?
Yeah, what are the consequences?
Well, it's considered fraudulent concealment, which is a big no-no.
Yeah, that sounds bad.
It is. The court could deny the person's bankruptcy discharge, which means their debts wouldn't be erased.
Ouch.
And in some cases, it could even lead to criminal charges.
Wow, that's a big risk to take.
It is. It's always better to be honest with your attorney about any transfers or unusual financial arrangements. They can help you figure out the best way to handle things legally.
So trying to trick the system is not a good idea.
Definitely not.
Okay, so we've talked about property. Let's move on to joint debts.
Yeah.
What are some common scenarios you've seen at Geraci Law with those?
One that comes up a lot is when couples have a lot of joint debt, like from credit cards or loans.
Right.
And when they decide to file for bankruptcy, figuring out who's responsible for what can get messy, especially if they're not together anymore.
So even if a couple is separated or divorced, they can still be held accountable for debts they racked up together.
Yeah, that's right. Just because a relationship ends doesn't mean the financial obligations disappear.
That makes sense.
Creditors just want their money back, and they'll often go after both people who are named on the account.
It's got to be tough for people who are trying to rebuild their lives after a separation or divorce.
It can be, and that's why it's so important to understand your rights and responsibilities when it comes to joint debts, both during a relationship and after it's over.
It's better to be safe than sorry.
Exactly. And it's another reason why getting legal advice early on is so important.
You mentioned earlier that Chapter 13 bankruptcy can sometimes be a better option for dealing with joint debts. Can you explain how that works?
Sure. So in Chapter 13, the person filing for bankruptcy presents a repayment plan to the court.
A plan for how they're going to pay off their debts.
Exactly. It outlines how they'll tackle their debts over a period of 3 to 5 years, and this plan can include ways to gradually pay off joint debts while also protecting co-signers or former partners.
Oh, so instead of one person being stuck with the whole debt, Chapter 13 can help spread out the payments more fairly.
That's the idea. By including the joint debt in the repayment plan, the person filing for bankruptcy can fulfill their obligation to the creditor while potentially shielding the other person from aggressive collection efforts.
So it's a way to protect both parties.
It can be. Of course, it depends on the specific situation and the agreement that's reached with the court and the creditors.
It sounds like Chapter 13 can be really helpful for managing those complicated debt situations where multiple people are involved.
It definitely can be, but it's not a one-size-fits-all solution. Every bankruptcy case is different, and the best approach really depends on individual circumstances.
Right. That's why it's so important to get personalized legal guidance.
Yeah, absolutely. Now, before we wrap up, I want to touch on something we haven't talked about much yet, the ethical side of bankruptcy.
Oh, yeah, that's a big one.
Yeah.
There are definitely some gray areas when it comes to things like informal agreements or trying to protect loved ones from financial fallout.
Absolutely. Bankruptcy laws are designed to give people a fresh start, but they also have to be fair to creditors and maintain the integrity of the financial system.
Right. It's a balancing act.
It is. And when you add in other people's finances, it can get ethically murky.
For example, we talked about putting an asset in a family member's name to protect it from creditors.
Right.
That might seem like a way to help someone you care about, but it could also be seen as trying to deceive the court.
Exactly. And even when there's no intention to deceive, the lines can get blurred.
Like with those promises to pay someone else's debt.
Yeah. Let's say you promise to cover your friend's loan, and then you file for bankruptcy. Legally, you might be able to get out of that debt.
But ethically, you're breaking a promise.
Exactly. So just because something's allowed in bankruptcy doesn't automatically make it the right thing to do.
It's important to think about the bigger picture.
Definitely, bankruptcy isn't just about the legal stuff. It's also about personal responsibility, financial accountability, and doing the right thing.
And those ethical considerations become even more important when you think about the consequences for other people.
Absolutely. You have to think about the ripple effects of your decisions, not just for you, but for your family, friends, business partners, anyone who's financially connected to you.
So, open communication with loved ones is key.
It is. Those conversations might be tough, but they can save you a lot of heartache down the road.
Avoiding those conversations could lead to misunderstandings, resentment, and damaged relationships.
Exactly.
Any other key takeaways you want to emphasize for our listeners before we move on to our final segment?
I think the most important thing to remember is knowledge is power. When it comes to bankruptcy, and especially when other people's finances are involved, the more you understand your rights, your obligations, and the potential consequences, the better off you'll be.
Don't just rely on what you hear from other people or what you think you know.
Right. Talk to an experienced bankruptcy attorney. They can give you personalized advice based on your specific situation.
Excellent point. And speaking of professional guidance, let's talk about what Geraci Law offers to people who are facing these kinds of challenges.
Sure, Geraci Law offers free consultations to anyone who's thinking about filing for bankruptcy.
That's great.
During that consultation, you can talk to an attorney about your specific situation, get your questions answered, and learn about your options.
So it's a no-pressure way to get expert advice.
Exactly. Geraci Law believes that everyone deserves access to quality legal representation, no matter their financial situation.
That's wonderful.
They offer affordable payment plans, and they work with their clients to make the whole process as smooth and stress-free as possible.
I understand they also offer some great educational resources to help people understand bankruptcy and their financial options.
Yes, they do. They have a free non-bankruptcy credit counseling course that's available online at infotapes.com.
That sounds like a valuable resource for anyone who's struggling with debt.
It is. It covers topics like budgeting, credit management, and debt reduction strategies.
So it's about giving people the knowledge and tools they need to take control of their finances.
Exactly.
This has been incredibly informative. We've covered so much ground today, from the legal nuances of joint debts to the ethical dilemmas that can come up when dealing with financial entanglements.
It's a complex topic, but hopefully our conversation has shed some light on the challenges and solutions that are out there.
I agree.
Mm.
Now let's move on to our final segment, where we'll leave you with some concluding thoughts and a thought-provoking question to ponder. Okay, so we're back, and it's time to wrap things up.
Yeah, we've covered a lot of ground today.
We have from joint debts to hidden assets to those informal agreements that can really complicate things.
It's a lot to think about, but the main thing to remember is that you don't have to go through this alone.
Right. Having a good attorney on your side can make all the difference.
Absolutely. And that's where Geraci Law can help.
Exactly. They have a ton of experience helping people navigate these complicated bankruptcy situations.
They really do. Their attorneys are experts at untangling those financial messes and helping people get a fresh start.
And they offer free consultations, so there's no risk in just talking to them and getting some advice.
That's right. Whether you're dealing with joint debts, property issues, or any other financial entanglement, they can help you figure out your options.
Now, before we go, we want to leave you with something to think about.
A question to ponder.
Exactly. Something that gets to the heart of all these ethical issues we've been discussing.
Okay, I'm intrigued.
So here it is. If you're thinking about filing for bankruptcy and your finances are tied to someone else's, like a spouse, family member, or business partner, should you involve them in the decision-making process?
That's a really good question. Legally, you might not have to tell them, but ethically, it seems like the right thing to do.
Right. It's about being honest and transparent and trying to protect those relationships.
And minimizing the potential harm that your decision could cause.
Exactly. It's about recognizing that your financial choices affect other people and trying to do what's right for everyone involved.
Well said. So, as you think about your own situation and the possibility of bankruptcy, think about this. Who else might be impacted by your choices? And how can you handle this whole thing with integrity and empathy?
Those are important questions to consider. And remember, Geraci Law is there to help you every step of the way. You can find more information about their services and those free consultations on their website.
And don't forget about their free non-bankruptcy credit counseling course. It's available at infotapes.com, and it's a great resource for anyone who wants to learn more about managing their finances.
Thanks for joining us on this deep dive into bankruptcy and financial entanglements. We hope you found it helpful.
And just a reminder, this was for informational purposes only and shouldn't be considered legal advice. For specific advice about your situation, please consult with a qualified attorney.